Yes, absolutely. Because
Why is that?
well, it's often um, necessary for the capital defense team to address this issue because prosecutors will often point to siblings as having uh, an upstanding life, uh, a good job, better education, and so forth, and they wanted an explanation of why is your client different? What influenced him differently? And that's a very important issue to study. And it is, again, it's not just the capital defense community that has examined that issue. There are books written by siblings of people who have committed murder. Um, Professor John Edgar Wideman, who went to University of Pennsylvania on a basketball scholarship, became a Rhodes Scholar, uh, and then a well-established writer. As a younger brother who committed homicide in Pittsburgh and went to prison, and so he struggles with that in his own writing. And then his own son uh, committed a murder as a juvenile. So people grapple with, why do some people with similar DNA, similar family backgrounds turn out differently? There's a professor at the University of California, San Francisco Medical School named Thomas Boyce, Boyce, who has a book called The Orchid and the Dandelion. And his metaphor there is that um, some of us are like dandelions. We grow up no matter where we are. Dandelions appear between the cracks in the sidewalk, and they survive into the world and flourish. Others are more vulnerable. And he wrote this book, I think, in part because of the experiences within his own family, where he had a sister who took her own life, and he was kind of grappling with that problem. Why do we turn out differently if we have uh, very similar uh, backgrounds, background environment, some of the same DNA? So I think those differences are kind of common sense issues that need to be addressed when you're telling the story of any individual's life.
And what are the tangible records that need to be collected to support a client's life story?
Well, anything that's got your client's name on it, and beyond that, whatever records you can get on the family members, caretakers, because sometimes the records of siblings, parents are just as important as the records of the client. They're going to identify things that the client doesn't remember, the parents don't remember. No amount of interviewing is going to elicit the information. A good example is from a case where the United States Supreme Court looked at the records of a caseworker in Virginia, and it's the case of Terry Williams um, versus Virginia. The year is 2000. I don't have the site in my head, but the caseworker's report was so vivid that the Supreme Court dropped it into a footnote, quoted it verbatim, and I don't have it memorized, but it's the impression of the caseworker who goes in and says, the home was a complete mess. People had bowel movements on the floor. There were puddles of urine, dirty dishes scattered in the kitchen. The children, including Terry Williams, didn't have any clothes on. The parents were too drunk to dress them when the caseworker found the clothes, and the children had to be taken to the hospital because they were under the influence of whiskey. These are small children. These are not 17-year-olds. These are, young kids. And that's an example to me that shows no matter how skilled you are at interviewing, you would not get that story from interviewing the client, interviewing the parents. Parents may give you a vague recollection of a time when neighbors complained about something and the police came and they were arrested and the kids were taken to the hospital, but they're not going to tell you there was feces on the floor, urine on the floor, and so forth. So the records give you a fuller picture. They identify people that the client doesn't even know exist, like that anonymous caseworker who wrote that report. Um, and they're also very helpful for when you are interviewing your client, interviewing family members, because they give you hard dates, where the family was living at a particular time, what school client was attending in fifth grade, and so forth. So they provide what I think of as a skeletal architecture of the client's life. And then the interviews that we do, we usually flesh that out.
Question. Earlier, you talked about how, going to the doctor, doctor asks you like about your physical family history going back generations. And you said that's important in terms of mitigation. Why are the previous generations, and is there a limit in terms of the generations that you go back to?
Well, the practical limit is it's often difficult to go beyond 3 generations, but just as some vulnerabilities medically, physically run in families, so they also run in families for mental health conditions. This is a brand new field. It didn't exist when I went to college. We know much more about the heritability of schizophrenia, for example. There's a study in Denmark of twins who are separated at birth and raised in different families. And the individuals who have no schizophrenia in the family, no schizophrenia in the adoptive family, the family environment, about 1% manifest schizophrenia later in life. But those that have the biological vulnerability, 9 times greater likelihood of schizophrenia. So again, it doesn't mean there's an automatic connection. Your mother had schizophrenia, therefore you're going to have it. But when you can see that a first-degree relative had a mental disorder, many of them have this strong heritable component. There's a researcher at Johns Hopkins who has written a number of books about mood disorders. And she's a brilliant writer, MacArthur Genius Grant recipient, but she also knows that we take in information visually. So she has family trees in her book. She has a book on mental conditions, mood disorders among famous cultural figures. So she has a genogram, a family tree of the Ernest Hemingway family. And everybody knows that Ernest Hemingway took his own life with a shotgun. But the family tree shows that his sister Ursula, their brother Lester, Leicester, and their father Clarence all committed suicide. So when you have that kind of biological lineage, that's important for any experts that you consult to know. You want to give them that information when they're starting out.
Let's talk about environments. Is home the only environment that matters in telling the life story of a client?
No, not at all. I mean, when I worked in California, we had people who came from very loving families, but had other factors that influenced their childhood because of the gang violence that was occurring on the streets of South Central Los Angeles, for example. So even though they had intact families, loving parents, to get to school, they had to negotiate a special route to avoid gang warfare. And on top of all of those sorts of influences, we now have everything that comes with the negative influences of the internet. kids that spend more and more time in front of uh, the screen, and it's very hard to monitor that. It's hard to regulate it, and we're only beginning to understand how that affects some particular individual's development.
Have you ever heard the term abuse excuse?
Oh, heard it for a long time. It comes from a book by Professor Alan Dershowitz, Dershowitz at Harvard Law. It's I don't even remember the full title, but it's disparaging the use of abuse as an excuse for crime. And that's not the case in mitigation. Mitigation never excuses what somebody did. It's just a reason why the punishment may be diminished.
And would you say that there are layers to this issue of abuse and the impact of abuse?
Definitely.
And so let's talk about also poverty. What are some of the layers of poverty in the mitigation lifestyle?
Well, again, almost all of the people who face death penalty prosecutions can't afford to hire lawyers. But before that, poverty affects healthcare, nutrition, which neighborhood the family is going to live in, what learning opportunities there are in the home. Are there books in the home? What kind of education did the parents have? So the word poverty doesn't mean much since it covers just about everybody in the client population. But when you drill down and see how it affected an individual's life, then we begin to see its importance.
And you talked somewhat about mental illness, intellectual disability. What are, and of course you talked about the brain development, and of course with that could possibly be brain damage. What are some of the contributing factors to brain damage as you come to learn in your experience in your work?
Objection, Your Honor. I think this goes beyond the scope of the expertise. He's asking what contributes to brain damage rather than asking questions about mitigation.
All right, I'll rephrase that. In your work, have you found out what could be a factor, a contributing factor to brain damage?
You're right, Jack. I believe that's the same question.
In your work, what have you seen in terms of your work, in terms of how it relates to brain damage?
Well, let me answer that in a couple of ways. I think we have learned that brain development in utero, in the womb, is very important. And the brain can be damaged by neurotoxins in the mother's environment, smoking, drinking. You see the warnings on alcohol and cigarettes. We also see trauma in the womb can affect the brain, but neurotoxins, that is things in the environment that an individual can be exposed to in their early years up through adolescence. The brain keeps changing, keeps developing. And again, the district attorney is correct. I don't claim expertise on neuroscience, but what I do know is that neuroscience has changed during the course of my career. What we know about the brain used to be what we learned at autopsy or what we learned accidentally in brain surgery. Now we have all these techniques for looking at the brain in real time with scans. So we know a lot more about how long this maturation process occurs. And that's much of the scientific literature that was submitted to get the exemption for people under the age of 18 in the Roper v. Simmons case.
And Mr. Stedler, the factors you just referenced as affecting brain damage, brain development in terms of what you learned over your years of experience, are those factors also consistent with trauma?
Yes, yes, absolutely.
Mr. Stedler, what does early life history matter as mitigation?
Well, it's when the individual is most vulnerable, not making any choices, living in a world that is foisted on him. And it's a time when there's the greatest vulnerability in terms of brain development, physical development. It's defining the world for the individual.
And have you ever heard the term free will?
Oh, yes.
Could you compare and contrast the whole free will concept with what you just have to say?
Well, I think the classic comparison is an extreme one, which says every choice we make in life is a free choice, versus there is some scientists that are completely deterministic, that say everything is just neurons firing and we're not making any choices. I don't subscribe to that. But I do think the choices that we're able to make are limited by all the factors in our early development, whether we're going to be able to get a good education, whether we're going to be able to choose to get an education, to choose to go to college. All of those are limited by where we fall in terms of the environment, in terms of the DNA. So the things that I've talked about in terms of development are things that limit our choices later in life.
Would it be fair to say that bad early childhood experiences can and will impact the adult choices that we make or client may make, even though folks are exercising what we call free will?
Yes, that's restating what I've said.
And in terms of those bad childhood experiences or trauma, why is it important to thoroughly explore or look at a person's experience with treatment programs or facilities?
Well, I should have mentioned treatment programs as something affected by poverty, for example. You may not get any treatment. You may not be diagnosed for a disorder because your family is poor and they're not psychologically minded and don't appreciate that maybe you should be evaluated. But the quality of the treatment program is also an important factor. Did somebody get an effective treatment program? Was there an accurate diagnosis of what was needed, and was the treatment appropriate and thorough, and did the treatment get its course completed? So institutional failure is another way of describing something that we look for in mitigation. If somebody was treated for drugs or alcohol, for example, did they go to AA? Did they go to some other treatment program? For how long? Was it effective? That's all part of the life story that we would want to look at.
I want to move into talking about looking at mitigation through all sides of the defendant, all sides of the client. Are there other aspects, other sides of the client in their mitigation that are particularly mitigating?
Well, I guess what I would say in response to that is, again, we don't want a deterministic picture that says inevitably this client was doomed to end up as a capital defendant. We want to show the hopeful parts of the client's life, the things with which all of us can identify, that, you know, the moments of opportunity that might have made a difference if only he hadn't changed schools or hadn't lost an important family member. And we want to show the positive things, the fact that, you know, when I talked about institutional failure, the fact that somebody went to AA for 16 sessions shows that they were trying, they were struggling. They wanted to overcome an addiction. And it diminishes the sort of mechanistic view that this person is an addict. It's somebody who was struggling with that problem. And so we look for the positive things too, because mitigation is about empathy, it's about kinship, it's recognizing somebody whose shoes we could be in, as opposed to somebody who's just different from us. Born bad, got worse, did nothing good.
Mr. Stephanie, you had mentioned brain damage, intellectual disability, mental illness. I want to ask a little bit about that in terms of those particular areas, especially in terms of adaptive functioning. In a case that involves intellectual disabilities, could you talk about the interrelatedness of the mitigation and what we call the adaptive functioning?
Well, the investigation of adaptive functioning is really very, very similar to the investigation we're doing generally in mitigation. Adaptive functioning covers how does this person coping with the world. And it's become much more important in intellectual disability cases than the IQ score. In the early years of the intellectual disability exemption, people were very much focused on scores and things that affected the error of measurement and norms obsolescence and so forth. But how somebody navigates the world, the social, practical, conceptual abilities, how somebody performed in school, how somebody learned to play football and follow all the cues that he needed to follow. All of those things are part of the important criteria for establishing intellectual disability, but they're also reasons for empathy, whether you meet the criteria for intellectual disability and exemption from the death penalty or not.
And what, you might have said, what are the areas, the domains of adaptive functioning that could be considered?
Well, for an Atkins case, an intellectual disability case, you need deficits in one of three areas: conceptual, practical, or social. And that there used to be 15 different categories, and they kind of compressed them all into those three. And most people are going to have problems in school, but some of them may have fewer problems in school, but more practical problems. They just can't learn how to cook, how to form relationships, how to navigate the world, how to change buses, what to do when the bus routes change. So they're all different kinds of things that we look at that are again, part of whether the person is functioning at a normal level.
Are these similar or the same type of mitigation that one would present even if the client was not intellectual?
Oh, absolutely. You know, we had a case where the client had an IQ in the 80s, let's say 85. So it was, and this was, I think this was before the Atkins case had even been decided. But we knew when you had a report from the school that your client was, that your child was functioning at this level, that was a lifelong condition. It was going to affect academic performance, vocational choices. Again, you know, that word choice, free will. He couldn't just go out there and apply for any job. His employment options were limited. So we had a school psychologist testify about what an IQ of 85 meant, one standard deviation below the norm. She was an excellent witness because she was used to communicating with parents, explaining what that deficit meant. And then he dropped out of school, went to a vocational counselor who took him to a rote employment job eventually because he wanted to get a job, wanted to work, did some training for restaurant work where they literally had placemats with outlines of the knives, forks, and spoons. So, you know, if you want to set the table, this is where the knife goes, this is where the spoon goes, this is where the plate goes. This young man also wanted to join the Navy as his father had, and could not pass the screening exam. So the naval recruiter liked him, gave him study guides, and I think, you know, a powerful fact in this case was the jury understood, gosh, if only this young man had been a little smarter, a little bit more capable, and had joined the Navy, he'd have been off on a ship and wouldn't have been exposed to these influences on the street, wouldn't have been a suspect in this case. So all of those things are things that are part of that mitigation picture.
And I want to just kind of follow up on that. Is that an example where adaptive functioning is relevant, not just in intellectual disability cases, but in cases where folks aren't intellectual?
Yes, absolutely.
Of course it does. Final question, Mr. Seven. Just for the court, how would you sum up what jurors need to know about mitigation?
Well, I think jurors have an awesome responsibility in death penalty cases, no question. Hardest decision a juror has to make. I mean, they're not involved in sentencing decisions in other kinds of cases. And so I think the importance of mitigation is not just for whether the individual gets the appropriate effective representation that lawyers are trying to provide and that they should provide, but also gives jurors and judges the full picture of who the client is so that their sentencing determinations can take a view of all the relevant evidence and reach reliable outcomes.
Yeah, at this point, I have finished my direct. I just asked if we could take a 5-minute comfort break before the state.
I would agree.
Okay, all right, we'll be in recess 5 minutes.
Thank you.
Yeah, let's get a little glass of water.
Let me see if
How long you take, Judge? How long you take? 5? Yeah, the judge is getting it. Yeah.
A nice filter system.
As long as it's H2O,
It is.
I'm not arguing. Thank you so much.
All right, I'll let Judge know. Thanks.
Thank you.
Before I brought it up. Yes, I appreciate it.
You know, from California to New York to
Back to him.
Atlanta.
Yeah.
Cameraman.
Yeah.
Your camera still live?
Senator, good morning.
Good morning.
I don't have many questions for you.
Council,
I
wait for.
gotta wait.
I apologize.
I gotta wait, okay? All right, okay.
May I please report, Kevin Armstrong,
Sean,
I will mention that I began one question, but everybody interrupted me because the defendant was not here. I say that for the defendant's
okay,
So I think it's now afternoon.
Not quite.
not quite.
Different clock. Sorry. How are you, Mr. Soto?
I'm well, thank you.
Good. I have just a few questions for you. You testified as to the purpose of mitigation evidence to provide the decision makers with the full picture to help them make their decisions, correct?
Yes,
Your experience has been from the standpoint of advocacy from the defense side, correct?
exactly.
So trying to give a fuller picture in the hopes that the defendant would receive a lesser sentence. correct?
Yes, that's correct.
Okay. In that vein, when you were referring to the purposes of a life story, you were referring to the negatives that come with an ecological perspective and what might happen that are negative in a person's life, correct?
Yes,
And so potentially presenting the absence of those negatives would be bad mitigation evidence, potentially.
I think there are too many negatives in the sentence.
Yeah, I understand. If you were to present a life story that omitted those negatives, that might be counterproductive from a mitigation standpoint, correct? If you were to tell a jury this person had a wonderful upbringing, this person had no gang influence, this person had no deficits in their nutrition and things of that nature, that might not be good mitigation evidence, correct?
Might not, but it could be very positive information about the individual that shows that what.
No, push back.
If you could repeat your answer, please.
Yeah, I'll try. I think if one had only positive experiences, it would just be a different kind of mitigation presentation then. I think you would then probably be arguing what an aberration the crime was in an otherwise, well-adjusted life. But one of the cliches of mitigation is that everyone is more than the worst thing that they've done.
When you were testifying about intellectual disabilities and you described categories relating to Adkins, the decision, and you said it had gone down from 15 to 3. Could you repeat those 3 categories for me because I didn't get them down?
Conceptual, practical, and social.
No further questions, John.
Any redirect?
No,
The doctor said it would be permanently temporary excuse for purposes of motion.
permanently.
All right, Dr. Still, I'm gonna,
Excuse me, Mr. Stetler. Thank you.
Michelle, I'll excuse you for the purposes of this particular hearing and, thank you for your patience, okay?
Thank you very much, Your Honor.
May it please the court. Here arguing on behalf of Mr. Long, motion number 41, a motion to ensure the mitigating circumstances are properly weighed. The court has heard from our expert, Mr. Russell Stetler, about why it is important that mitigating circumstances are properly weighed by the jury and remedies that we're asking, that we want to be able to question jurors about mitigation. I know the court will accommodate on that with us, but we thought it was very important to file this motion because we believe that this is not a hearing that we could have in the middle of war time. It's not an argument that any of us, I think, want to have in the middle of war time as to how relevant is Mr. Long's life story. How relevant is it that we want to present or ask jurors about family history, social, mental, emotional, physical. So that is why we've done this. And so we want to also ask as a remedy that at the appropriate time that we be able to propose and submit an instruction that speaks to making sure that the mitigating circumstances are properly laid.
All right, sir. Mr. Armstrong?
Yes, Your Honor. So there will be some agreement. There's also some disagreement with motion 41. As I've laid out in the response, there are things about which the state has no qualms, such as the court providing, say, the appropriate pattern instruction on mitigation, and making sure that the jury is properly qualified and follow the court's instructions on mitigation. There are other issues, such as Ellington factors, that if the defense raises, we will consider on a specific basis. And Ellington factors are considered critical facts that the jury can be voir dire on, that are something like child killer or cop killer, things like that, that Ellington identified as having a phrase for it. If there's such a fact such as that, then that'd be something to be appropriate for voir dire. However, the defendant, if they're asking to ask specific questions about mitigation, such as how would this juror be receptive to specific types of things, such as family history or emotional or physical evidence, and asking them questions like that and how it would affect them, then that is something that requires the jury, the potential jury person, to prejudge the case, and those questions are forbidden under Georgia law. And Willis versus State, which we cited yesterday for a different purpose, is one of the most recent iterations of that rule, where you can't ask questions similar to that. And so, to the extent that they're asking to ask specific questions about mitigation evidence that they intend to raise, and specific types of mitigation evidence to see which jurors are more likely to go along with them or not, those are questions that prejudge the case. And so the state would object to those, but we won't know what they are exactly referring to until we get there. I will point out to the court that the regular pattern instruction on mitigation, similar with Georgia law, does not define mitigation, and that is to the defendant's
defendant's motion is to mediate circumstances. There are a couple of things that come to the court's mind. Ms. Bell and Mr. Lamar, you'll be able to submit what are questions that you think are appropriate and proper. I do agree with Mr. Anderson. You cannot ask questions that ask the jury to prejudge the case. I understand how important mitigation evidence is, but there's a time and place for it. So, not to say that I will not permit you to present mitigation evidence, but I'd ask you to follow the law in terms of those questions are acceptable for the purposes of one dire. In terms of an instruction, if it should get to that point, and I'll consider any lawful instructions to include the pattern instructions that are based upon what evidence is presented in this case. So what I'm going to say is I can't really move on at this point in time because I don't have anything specific to look at, either in terms of questions or in terms of jury instructions. So I'll defer ruling until such time as I have questions that prompted me. But just generally as mitigation circumstances, I don't believe that you'll be able to get into the jury during one dire itself unless they are asked in terms of, as Mr. Anderson pointed out, critical facts. So that's distinguishable between and other case law, which is distinguishable. So, like I said, without anything specific, I'm at a loss to rule with some particularity. Okay.
Yes, Your Honor, and I'd just like to respond both to Mr. Armstrong and to the court. That is always where the kind of rubber meets the road in terms of what we see as possibly prejudging cases. But I would say to the court and to the state that to make sure that mitigation receives its proper due, you have to have jurors that are willing to hear. And I will use an example. I know the court says we don't have anything, but let's just talk about mental illness, right? Asking a juror what they think about mental illness is not shocking your mitigation. It's not shocking or asking them to prejudge, because if mental illness, let's just say it's a defense, or it's going to be, and it will be presented possibly in penalty phase. That is not asking them to prejudge the case. That is an element of the case, element of mitigation that when we ask them the three questions, the questions about will they consider life with, will they consider life without, will they consider death, they have to take into account all of that. So a lot of times in the cases I've done, that's where the argument falls. You're asking them about mental illness, you're shocking your mental illness. No, that is part of it. So
If you decide to present that as part of your case in chief, well, and you can certainly, the law presupposes that you're not required to present anything. However, it's a very fine line about what you can get into in terms of asking the jurors about specific things to prejudge the case. So take a look at that case law again, because I am.
Right.
And I'm gonna look at it in terms of whether or not it can be asked or not. So that's the only I can guarantee that I'll do at this point without anything more.
right, and I just want to say to the court, I clearly understand what you're saying, but I ask the court to also consider that jurors have to be able to consider mitigation evidence. And if a juror cannot consider mitigation evidence, if the juror says, forget that mental illness stuff, that's just, y'all gonna put the doctors on and stuff like that. We need to know that. We can't wait until they're in deliberation and then we find out the juror said, man, I don't believe in that mental illness stuff. We need to hear that beforehand, so at least I have a chance, or the state has a chance to strike that person. But I understand what the court is saying, but I just use that as an example of many times the back and forth between the state and the defense in these cases.
Well, you submit the question,
Yes.
and then I'll take a look at them, and based upon what is case law and other arguments, I'll rule accordingly. But I understand that there's a fine line between you're not required to present anything. So, but then again, on the other hand, there are other issues if you try and insert things that might be in violation of case law. Okay, so I got to take a look at it, to be honest. There's no way I can rule on it quite yet.
Very well.
I can't at this point. So, all right. Okay. All right, folks. The hours 10 after 12. Only takes me much, and we'll come back at 1:10. So, Mr. Anderson and Mr. Lamar, Mr. Armstrong, and Mr. Lamar, if you all prepare a board just saying that I will move in terms of mitigation action number 41, I'll just take without looking at the specific questions you're going to ask. I can't kind of look at it in context, okay? And the other thing I also want to say that I will take a look at whatever and your instructions as appropriate. Should we come down to that and determine that based upon the facts and evidence in the case, okay?
Yes, sir.
All right. Okay, so when we come back, we'll take up some other motions that we'll take up today. I think that's the only one you have that has evidence. I mean, has testimony, correct?
Correct.
Okay, all right. Before we go off, folks from the AJC, you got, I should say from Channel 2, you got to cut your camera off when we are not in court, okay?
Okay.
Okay, because you can't film anybody else or anything that's going on in the courtroom, okay? Just want to remind you about that. We did see, somebody told me, they called me, said the camera was on, okay? All right. Well, we're recording. All right, that's the only thing else I have. So we'll see each other at 1:10, okay? All right, release that.
Okay, I'm sure criminal day after Ethical Frank can be recessed until 10 hours. Criminal can be locked in security, detention area not clear. Should be in process.
Welcome to the mic, it's the Dennis Byron Show. Breaking headlines, truth in every flow. From courtroom seats to exclusive shots. Journalism raw, yeah, Byron calls the shots. Subscribe, stay woke, now let's get in the know. It's the Dennis Byron Show. Dennis Byron Show. It's the Dennis
bank, and he actually talked to me.